So we were at common law and law of statute. And as we discussed, common law, which is also called case law or law of precedence, it is different from law of statute. Although common law is also based on the statute only, but here the more weightage is given to the pre-decided cases. So the reference always in a common law, when the judgment is going to be passed, we always take a reference of the previous decided cases. While in law of statute, it is strictly based on the act or the statute. That is the difference. So common law following countries, as we discussed, are Canada, United States, and the England, and all the Commonwealth countries which were ruled by England, colonized by England in the past, which includes India and some African countries like Ghana and all, and some Southeast Asian countries. And Canada and US and England, they follow the common law. Now, who follows the law of statute? The law of statute is followed by the European countries. They do not give much precedence to the pre-decided cases, but the act. So, Sydney, you have any issues? Hi, Sydney. Do you have any question?
No, you were just saying hello at the beginning of the lecture.
Okay. Thank you. Okay, so coming back to the point. So initially, we'll go to the common law first. Initially, word of mouth from generation to generation means the rules or the precedences set by the courts. Written records improved, eventually becoming useful statements of law. So when a case is again and again decided in a particular manner, that decision itself takes the place of a law. This is law now found in the recorded judgments of the courts and known as case law. So from here, it is having another name, which is case law. So if somebody says, even in your exam, if you find the word common law or case law or law of precedence, all three are same. Don't get confused. Okay. Now, the important thing is the doctrine of stare decisis, which is very important because this doctrine is the one which rules the common law, which is the principle. This is the principal doctrine of common law. Here, as per this doctrine, decisions are based on to stand by a previous decision. So, if you cite during the legal proceedings the reference to a previously decided case, that is considered well. Okay, so doctrine of stare decisis is the basis of common law, and or you can alternatively say that common law is based on the doctrine of stare decisis. Okay. Now, other specialties of a common law, that decisions are made by the king, because this is the from the time when there was no officially regarded courts, but the king, monarchy was there. So whatever kings was deciding becomes the decision, and it takes precedence over any written act. But in the modern era, when there were court system established, now whatever the judgments are given by the courts, they take precedence. Main principle is that decisions are based on the doctrine of stare decisis, means to stand by a previous decision when a later case presents similar facts where the original decision was providing. So remember, the facts should be same. You will cite only a previous decided case when the fact is same. If the fact is different, you cannot refer some arbitrary previous given statement or decision and you take a reference as a precedence. No. If in the same circumstances and in the same facts, if you are finding that things are same, you go with the same decided decision. Okay, so it has to be from the judge's own court. It should form a court of equal rank, and it should be from a court of higher rank. Means if you have a district court, if you have a high court, or if you have a supreme court. So if you are if you are discussing, if you are having legal proceeding in a district court, so the reference decision should be from district court or any court higher. Means you can cite any Supreme Court decision, High Court decision, or any district court decision in the district court. It should be either from the same court or the court of higher rank, not the court of lower rank. For example, if you are in High Court and you want to give a precedence, you should either select any previous High Court decision or any Supreme Court decision. You cannot cite any district court decision in a High Court as a precedence. Similarly, when you are arbitrating or you are having a legal proceeding in a Supreme Court, you can only cite the previous Supreme Court decided case as a precedence during your proceedings. You cannot refer any district court decision because that court is inferior court as compared to the Supreme Court of Canada. All right. So the rule for use of doctrine of stare decisis is that it should be either from the same court or any court of equal rank or any court of higher rank, not from any court of inferior rank. That will not be admissible.